Good morning. Can you hear me, Mr. Citro?
Yes, I can hear you fine. Thank you.
Wonderful. Should I begin?
Good morning.
Good morning, Mr. Sasso.
We know each other. My name is Mike Sasso. Welcome to the JNC. The way we're going to proceed this morning is we're going to go around the virtual room, and all the commissioners are going to introduce themselves, and then you'll have about 3 or 4 minutes to make an opening statement, and then you'll be questioned, and the questioning will start. I assigned Commissioner Citro to vet you, so he'll start your questioning, and then we'll go around the room and all the commissioners will ask questions. And then I'll keep an eye on my watch, and I'll give you 3 or 4 minutes at the end to make any closing comments you'd like to make. So no further ado, again, good morning. My name is Mike Sasso. Commissioner, excuse me, Commissioner Carl. Amanda?
Good morning. Good to see you. Amanda Carl at A2 Sons here in Oviedo.
Commissioner Andy Bardos.
Good morning. Andy Bardos with Gray Robinson. I'm in Indianapolis.
Commissioner Lauren Blocker.
Good morning, Lauren Blocker. I'm in-house counsel at FIS and I'm in Ponte Vedra.
Commissioner Vincent Citro.
Although we know each other, nonetheless, Vincent Citro, the law offices of Horowitz and Citro in downtown Orlando.
Commissioner David DeArmas.
Hi, I'm David DeArmas at Kramer Price and DeArmas in Orlando.
Commissioner Craig Dyer.
Hi, Craig Dyer. I'm from Daytona Beach and recently retired Chief Assistant at the Public Defender's Office.
Congratulations.
Commissioner Carrie Eisnagel.
Good morning, Carrie Eisnagel. I'm in Sanford.
And Commissioner Scott Thomas.
Good morning, Scott Thomas with the Burr Foreman Law Firm. I'm up in Ponte Vedra Beach, St. Johns County.
Okay, Ms. Nardella, you have the floor.
Well, wonderful. I want to begin by thanking the Commission for the opportunity to speak with you today. My name is Mary Alice Nardella, but my colleagues know me better as Molly Nardella. I'm an estate planning and transactional attorney in Orlando, Florida. My husband and I built a law firm called Nardella and Nardella, and I run the estate and trust department. I put my name in for the vacancy created by Justice Grosshand's elevation because I believe that I can make a difference, and I'm sure I share with you the view that that is the purpose of our life. The 5th District Court of Appeals is the court of last resort for citizens that have disputes in 13 counties throughout our state. Its opinions will bind those citizens, but they will do something more. For citizens throughout our state, the opinions that come out of the 5th District Court of Appeal and the legal reasoning in them will help them order their affairs. I offer to those citizens 3 things. I offer a demonstrated work ethic. I offer experience in substantive areas of the law, which are difficult and nuanced. And most importantly, I offer a fully formed judicial philosophy. I offer respect for the proper role of the judiciary in our structure of government. And I offer the courage and work ethic to make those principles count. So I thank you for this opportunity to have a conversation, and I look forward to your questions.
Thank you. Commissioner Citro.
Thank you. As I start, I want to first say, forgive me if you see me looking off to the side. Part of my role today is the moderator and host. So I'm admitting people and making sure mics aren't active and videos aren't active. So that's no reflection on your answer. So we know each other. I referred work to you. Your firm has referred work to me. So I asked these questions with that background in mind. One, when's the last time you were in trial?
About 3 years ago, when I was leaving Rumberger, Kirk and Caldwell, I stepped in to help with a trial that was days away from going. I delivered the opening statement. I helped with jury selection. Ultimately, it did not go to verdict. I believe about 4 days in was the last time I was in trial.
And your last oral argument in front of any court of appeals?
In 2018, I argued in front of the 2nd District Court of Appeals in a case involving a community bank where my clients had taken out a loan of about $27 million. The case was actually 2 appeals, but ended up settling before the 2nd appeal was heard by the 2nd District Court.
So in the course of doing your background, I heard many wonderful, glowing things about you, which I of course knew to be true from our personal experiences with each other. But one of the things that a lot of people talked about was your judicial philosophy, which you've referenced in your opening. what I'd like to know more about from you is any Federalist Society member hears the word consulting legislative history, it's almost a violent reaction. Whereas a conservative judge who references the Federalist Papers, those same people almost faint with euphoric joy. So explain to me the difference between consulting legislative history to determine a meaning and going to the Federalist Papers to determine a meaning.
Well, I would just cite for you the Mcdonald opinion. The Mcdonald Concurrence was written by Justice Clarence Thomas, and he did that. He looked at a lot of sources of history, and one of them was sources that would be called today legislative history. And he laid out in the opinion the very purpose for which that he was looking at those sources. And what he clearly stated is he didn't care about the draftsman intent. That's not why he was reviewing those sources. He was looking at them as persuasive sources of original public meaning. He was trying to determine how the phrase, in that case, the privileges and immunities phrase, was understood to mean to the proficient English speaker at the time that it was put into the 14th Amendment. So that would be the distinction.
And if you would flesh out for us your view of stare decisis.
I believe that stare decisis is important to the stability of our judicial system. I think everyone shares that view, but it is not an inexorable demand, and it never has been. Blackstone talked about that, stare decisis doesn't stay when it's a poorly reasoned decision or it's errant. So stare decisis, as Justice Thomas said, it's not an inexorable demand. There are exceptions to stare decisis. And my view is in line with his decision in Gamble, and I would certainly follow the precedent laid out in State versus Poole.
I could do this with you all day long, but I'm going to defer to my other commissioners so they have a chance to ask you some questions. Thank you.
Thank you.
Okay, Commissioner Amanda Carl.
Good morning, Molly. Good to see you.
Good morning.
And kind of in the same boat as Mr. Citro, you and I know each other well. And so I think I will defer questions to the end to save questions for anyone else who might have something specific to ask.
Thank you, Commissioner. Commissioner Andy Bardos.
Good morning. How are you?
Good morning. I'm well.
Good. I would like to, and you have a very impressive resume, and I've heard many good things about you, but I would like to look a little bit closer at your legal practice over the last 4 years or so, just to shore up a couple of questions that I have been looking at your application. So when I look at your financial disclosure on page 37 of your application, where you list the gross income that you have received from legal practice over the last 4 years, from 2017 to the present, the amounts are quite modest. And so I wonder, how many hours have you worked on billable matters in each of the last 4 years?
Certainly. So to address that, I would say this. I left Rumberger, Kirk, and Caldwell in 2017. At the time I left, Nardella and Nardella had 3 attorneys. I was the 4th attorney. My husband and I are fairly financially conservative. And so I didn't take an income when I joined the firm because the firm needed to grow. And the firm has grown. The firm has grown from 3 attorneys to now we have 11 attorneys practicing under our umbrella. And so the choice was made in that year for me not to take an income, knowing that if we hit our goals, if we made our markers, that my husband would be taking what was left as a distribution, and we share and share alike. So I could see where that would pop out to you, but that is what I would say. When it comes to the practice of law, I would estimate that my day is split about 50-50 between management of the firm and those responsibilities and the actual practice of running the Estates and Trust Department. I would estimate that since I began running the Estates and Trust Department, I spend about half of my day or 25 hours a week on the practice of law.
Why did you choose to shift from a litigation practice to an estates planning practice?
Certainly. So when I was a litigator, I had zero control of my schedule. My husband was a litigator as well. And the decision was made when I joined Nardella and Nardella to help build an estate planning practice where you have just as much work, but you have more control over your schedule. And it gave us that opportunity for our family while it was growing.
Okay. During your time at Rumberger, did you ask to become partner?
I did not.
Why did you not ask to become part?
Well, typically in the firm, I left at about coming into year 8, and that's about the time when associates are made partner. And I left before that decision would have been made on my behalf to help my husband to build Nardella and Nardella.
Okay. All right, great. Thank you very much.
You're welcome.
Commissioner Lauren Blocker.
Thanks. I just have one question. In shifting to a transactional practice, are there any skills that you think you're developing that are applicable to the appellate bench?
Absolutely. So the transactional and the litigation practice are very different. And obviously there's some skills in litigation that I bring to transactional, but the transactional practice is heavy evaluation, analysis of very different areas of the law, whether it be tax or homestead, whether it be the regulations which govern a client's medical practice. So you pull from a wide variety of areas of the law in order to help your client come up with the best plan that serves their family or their business. And so the ability to write, which is what I do every day I draft, and the ability to see the law in a big picture way is something that I would bring to the table.
Thanks.
You're welcome.
Thank you, Commissioner. Commissioner David DeArmas.
Hi, Molly. I kind of feel like we should know each other, though we don't. My question has to do with PCAs. I'd like your thoughts on PCAs, maybe specifically in the 5th DCA.
Okay.
But are they used too often, not often enough? Should they be used differently? Just what are your overall thoughts on PCAs?
So my overall thought is coming from a private practice perspective. I deal with clients who have poured in time, energy, money, and are going to be very disappointed when they don't have a written opinion. So I would carry that perspective with me. In general, though, I believe you write when it furthers the body of law. And that's the question that I would ask myself on the bench.
Thank you.
You're welcome.
Thank you, Commissioner. Commissioner Craig Dyer.
Again, good morning. What do you believe that Governor DeSantis is going to be looking for if you have the opportunity to go to Tallahassee when you have that interview?
I think he's going to be looking for somebody with the intellectual capability to do the job well. I think he's going to be looking for somebody who can articulate their methodology. I think he's going to be looking for somebody with the highest ethical standards, someone that has humility and understands the proper role of a judge in our system of government. That's what I would expect him based upon some of the speeches that he's given to look for.
Okay. Thank you very much. I have no other questions.
Thank you.
Thank you, Commissioner. Commissioner Carrie Eisnagel.
Hi, Molly. Of course, we know each other, but we really not had the opportunity to discuss your philosophy and so forth. What do you believe is the role of a judge?
I believe the role of the judge is to say what the law is and not what the law should be. I'm sure you've heard that a million times. But I believe the role of the judge is to understand that they belong to a particular branch that has a particular role, and that the structure of government is ultimately the most important thing.
So can you elaborate on that? Why is it important for a judge to stay in their lane?
Well, when you have democratically elected, responsive to the people branches, the people need to know that that's where they go for change. That when it comes to the interpretation of the law, you go to the judiciary, and the judiciary is going to apply a fair, even-handed, known methodology to ascertaining the meaning of law. I think that's very important to our system of government. And I think when you create confusion by usurping powers that don't belong to you, it's difficult for the people to know where to go. I think a great example of that may be if you look at the constitutional amendments that were passed originally for this country. I believe it was one constitutional amendment every 11 years. But when the court started taking what I believe was power away from the legislature, you see a vast decrease. I believe it's 40, 50 years. It's a dramatic number in decrease. So I think it's important to our system of government that the judicial branch respect its proper role in our system.
Thank you. And how do you go about interpreting a statute?
Okay. So I'm a textualist. I believe that words have ascertainable meaning. I try to give the text its plain and ordinary meaning. If it does not arrive at the best reading, what I would do next is look at the grammatical canons. I would apply those canons of construction to the statute to find the best reading. If the statute was ambiguous after that process, I would then look at the substantive canons. For example, the rule of lenity, for example, the rule that anything in derogation of common law is strictly construed. But I wouldn't get there unless there was an ambiguity, and I wouldn't start with the question of whether or not a statute is ambiguous.
Thank you so much. I don't have any further questions.
Thank you, Commissioner. Commissioner Scott Thomas.
Thank you. If I could return to the kind of the last question there, you described yourself as a textualist. Earlier in discussing, I think Justice Thomas's discussion of original public meaning, I think the constitutional sense that textualism becomes originalism. So I assume you're an originalist, a textualist. My question is why? What public interest is advanced by those modes of interpretation, and how does it advance those public interests?
Well, I think as I was discussing with Mrs. Eisenagel, when you are a textualist and originalist, you have a known methodology. You are not, as Scalia would say, out at sea with the tides of the time. You have a known methodology, and I think that gives great reassurance to the public that they are getting a fair and impartial adjudication that's not based upon a particular judge's preferences. Because when you're a textualist and an originalist, you show your work. It's there in your opinion. Somebody can see how you got there in a fair way. Does that answer your question, Mr. Thomas?
It does. It does. And let me also return then to the stare decisis. I recognize that it's not an inexorable demand, but are there doctrinal guidelines that you think apply? In particular, for example, does it matter if we're dealing with matters of constitutional interpretation versus statutory interpretation?
So that's a great debate in the community right now. And I have heard arguments advanced that it should matter. And those arguments make sense. But for me, ultimately, the big picture question is, what is the role of a judge? And I don't believe the role of the judge changes based upon what the source of the law that you're interpreting. So until there's further guidance on this, I would apply the same strength of stare decisis, whether it was the Constitution, whether it was a statute, or whether it was common law. But I can see that there are good arguments, especially based upon Gamble, for treating them differently.
What would you give consideration? I guess if the court gets a matter of statutory construction wrong, there's a ready fix for the legislature. If it gets a matter of constitutional analysis wrong, I'm not terribly sure I know what the fix is.
No, and that's the argument that's put forth, right? And it's a strong argument. But in some ways, you could say the same in the state of Florida for a constitutional amendment. That could be the fix. So in my big picture,
It's readily easy in this state, unfortunately.
it's readily easy in the state, and it will apparently remain so. So to me, it comes back to the big picture question of the role of the judge. But I think it's a strong argument that you make, and I've heard others made.
Well, I appreciate it. It's good to meet you, by the way. We've not met before, although I was not the person vetting you, but I received so many unsolicited calls about you. I feel that I was. So it's a pleasure to meet you in person through this format.
Thank you. It's nice to meet you as well.
Thank you, Commissioner. I just have a couple of questions. This is a hypothetical. If you could only keep one, the separation of powers in the Constitution or the Bill of Rights, which would you select and why?
That's a wonderful question. And before his death, Justice Scalia talked a lot about this very persuasively. And what he said is that you can have all of the rights in the world, and he would point you to the constitutions of countries where there's no respect for the rule of law, where there's no real human rights. You can have all the rights in the world, but they're mere parchment promises if you don't have separation of powers. And I talked a lot about that in my application, but I think it's very important to keep power diffused. I think our founders recognized that, and I believe that to be true. So I would choose separation of powers.
Okay. Is the question of whether the dormant commerce clause consistent with the original public meaning of the Constitution judicially manageable?
Wow. I can't say it's something I've thought about,
Okay.
but it is something I will think about from here on out. So thank you for giving me that question to really think about. Is it judicially manageable?
Yeah.
I mean, it's already been so greatly expanded, and I think you go back to the give and take with Clarence Thomas trying to bring the court back to a more original interpretation, and he would probably say no.
Okay. One last question.
Mhm.
There's some disagreement in the state amongst the district courts about whether it is appropriate for a court to address unraised fundamental error in civil cases. What are your views on that?
I think
I know criminal's different. In a civil case, what are your views on a court raising or addressing unraised fundamental error?
I think it goes back to the role of a judge again. The job of a judge and the restraints put on the judge are to rule on the areas that are set out in the initial briefs. And in the civil world, if a fundamental error was not put into the initial brief, there's a different question maybe about preservation. But if it's not in the initial brief, then I don't think it's the proper place of the court to reach out and grab it.
Okay. Well, that will conclude the Q&A portion of this interview, and you have 5 minutes to address the commission.
I know you guys have a long day in front of you. I want to thank you for the opportunity to have this conversation. And I would just ask that at the end of the day that you would consider sending my name to the governor. So thank you very much for your time.
Thank you, Ms. Nardella. Have a wonderful day.
You as well.